Welcome everyone, this is Amer Mushtaq from U Counsel. When you are instituting a workplace investigation, you have to select the right investigator for that particular issue. It is an important step, and choosing the right investigator is crucial to the conduct of a proper investigation. So why is it important to choose the right investigator, and what are some of the qualities of the right investigator? We'll talk about that in today's lecture. We begin with our disclaimer that this course is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. So hiring the right investigator is important, but why is it important? Let me give you some specific answers to that. Number one, the investigator has a very high burden, and I'll explain what I mean by a high burden. And secondly, there are significantly negative consequences of a badly conducted investigation, and I will explain that point more in the next slide. I'm using the word investigator's burden purposely. I believe that, yes, it is an investigator's responsibility to conduct a proper investigation, but it is also a burden. The responsibility is so high that I believe the word burden is appropriate, and it needs to be discharged with respect to the investigation, with respect to each employee that is being interviewed, with respect to witnesses, with respect to accused, and with respect to the accuser. And sometimes this burden is even higher than a judge's burden in a court system. And what do I mean by that? To understand that, you need to understand that the investigation process is an inquisitorial process and not an adversarial process. There's a difference between an inquisitorial process and adversarial process, and let me explain to you what that difference is. So adversarial process, our courts and our judicial system works on an adversarial process system. And what is meant by that is that a judge makes a decision on a case based on competing evidence that is presented to that judge. So in an adversarial system, there are two parties. One is the plaintiff, one is the defendant. The plaintiff hires his own lawyers or her own lawyers. So does the defendant. They bring their own evidence to the trial and they present their own case. And what the judge will do is the judge will look at the evidence, the case of both parties, and then decide which party is more compelling, which case is more compelling, and may the best case win. In a court system, in a judicial system, the judge has no responsibility to conduct his or her own investigation. There may be question in judge's mind that may require further investigation, but that's not what the judge's role is. In an adversarial system, in an adversarial judicial system, we as a society believe that when both parties, opposing parties, are allowed to present their case to the best of their abilities, somehow we believe that there is a level playing field for both parties. They can both present their best foot forward, and the truth will invariably come out because of the presentation of cases, and the best case will win. The truth will come out. That's our concept. And so in an adversarial system, the judge is not conducting any investigations of the judge's own will. It is based upon whatever is presented. So in a way, judge's job is relatively simpler because whatever evidence is presented before the judge has to choose between the competing evidence before him, and whichever one makes sense, whichever one is more compelling, the judge rules in that party's favor. But an inquisitorial process, the investigator has the burden to search for the truth. So when you hire an investigator, there are no competing versions. The competing versions are to be determined by the investigator himself. So the investigator will talk to the accused, will talk to the accuser, will talk to the witnesses, will look at the documentary evidence, and then determine what the truth is. So the role of the investigator is much higher, the burden is much higher in an investigative process because it is the investigator's job to search for the truth. Also, in an adversarial process, the judge will invariably rule in one party's favor, right? So either the plaintiff will win or the defendant will win. One of the two parties has to win based on the competing evidence they have provided. In an inquisitorial process, it is possible in some cases where the investigator may conclude, having reviewed all of the evidence, having spoken with all of the witnesses, the investigator may conclude that there is no factual determination of who did what, in terms of being wrong, right? So who committed an offense, who committed harassment, who committed a mistake that warrants some sort of punishment. The evidence may lead to lack of conclusion, and it is possible in an investigative process, whereas an adversarial process in a civil court system, there's always one party that is going to win and one party that is going to lose. So inquisitorial process, the entire burden comes on the investigation. Yes, the investigator is going to ask the witnesses to provide their evidence and whatnot. But at the end of the day, it is the investigator's job to look for more evidence if the investigator needs to search for more. Investigator needs to take the investigation in the direction that it ought to go. And all of these decisions lie with the investigator to conduct a proper and thorough investigation. What are some of the consequences of a badly conducted investigation? The major consequence are legal consequences, right? A badly conducted investigation will not hold when challenged in a court. So if the matter goes to court and in that court process, the investigation that was conducted is also examined by the court system, and if it is not properly conducted, it is not legally defensible, and then it may end up harming the company, the employer, more than having not conducted an investigation. So a badly conducted investigation has legal consequences. It has obviously economic consequences. It costs money and resources to conduct a workplace investigation. And if you conduct a bad investigation or you hire an incorrect investigator, then the investigation you have conducted may not be proper and you have lost your time and resources for that. And obviously, there are workplace consequences. If the investigation is conducted badly, that means that the truth has not been properly determined. That means that proper legal actions may not be taken. That means the wrong party may have been disciplined, and all of those consequences flow from a bad investigation. And therefore, rather than repairing the workplace, rather than repairing the relations, the investigation has now harmed the workplace process. So with that in mind, with the importance of hiring a good investigator, a proper investigator, what are some of the essential qualities of an investigator? And these are essential qualities, and I believe that an investigator has to have these qualities. The most important one is neutrality. An investigator must be neutral, and I'll explain this in a bit more detail. Secondly, competence. The investigator must be competent in conducting an investigation, and the investigator should be able to do his or her job efficiently. Let's talk about neutrality. So, first thing about neutrality, which obviously makes sense, is that there should not be any conflict of interest for the investigator. And this is a scenario that often may present when the company is hiring an internal investigator, when a subordinate employee has made an accusation of some sort against the manager. It is very obvious that the manager should not be the one conducting that investigation or should play any significant role in that investigation because the manager has a conflict of interest. But at sometimes the manager's own boss may have an indirect conflict of interest because the investigator's boss may have some interest in protecting his or her own manager as opposed to the subordinate worker who has filed a complaint. So conflict of interest is an important factor, and the investigator should not have any conflict of interest, either actual or perceived. So either actual or perceived, there should not be any conflict of interest on part of the investigator to make sure that the investigator is neutral and unbiased. Secondly, there shouldn't be any circumstances that should cause undue influence on the investigator's ability to conduct investigation. And so one of the things that, that may occur again in places where investigator and the parties who will be investigated, or the accused or the accuser, kind of know each other, work in the same company, even though they may not know each other directly, there may be some undue influence. And we know that workplaces have their own dynamics, they have their own cliques, they have their own relationships, which do play a role in terms of various decision makings that occur within the workplace environment. And that may be all fine with respect to day-to-day issues, but when it comes to an investigation, there should not be any undue influence on the investigator. So undue influence could be in subtle ways. So for example, a human resources person who may be conducting an investigation, may have friendships with the manager, who has some interest in the outcome of the investigation, and that relationship, social relationship, may cause some undue influence with respect to the conduct of the investigation. So it is important to ensure that there is no undue influence on the investigator to conduct investigation in an impartial and unbiased manner. And then thirdly, there should not be any prejudice or preconceived judgments about what may have happened with respect to the issues that are being investigated. And I think that part is, again, very important when internal investigations are conducted by employees or other by employees from HR, from human resources, or other employees within the organization. And I'll explain this to you by way of an example. Many years ago, I used to be a naval officer, and the way it works in the Navy is that if a sailor is charged with an infraction, that infraction, the judge is usually the commanding officer who listens to the charge, and the regulating officer presents the charge, who acts as the prosecutor, and the sailor's officer, departmental officer, becomes the defender, and then the charge is presented, and the commanding officer makes a decision. Now, in a small ship of 50, 60 people, everyone knows everybody else. And so when a sailor is charged, it is obvious that that sailor's background, his social relations, his interactions, his general impression in the workplace is known to everyone. And so I remember in one case, I was defending one of my sailors who was not very well liked within the ship's company. He was socially awkward, people didn't like him, he was not very presentable, his social demeanor was not very well liked, nothing to do with his legal defenses, but he was just not liked, including myself. I didn't, even though he was in my department, I did not very well liked him in so many ways. And so I had to defend that sailor. When the charge was presented and the sailor had to step forward, what I did at that time was I presented a different sailor to come and step forward, even though my sailor was being called. So when my sailor's name was called, the sailor who actually stepped forward was a different sailor, and this was a sailor with the same rank, but he was very well liked, he was very well respected within the ship's company, and he stepped forward. And my commanding officer was obviously puzzled. He looked at me and he said, "Lieutenant, why is this sailor here? I believe the charge is against a different sailor." And then I told my commanding officer, and I said, I have brought this sailor just to make a point. When you are considering the charge against my sailor, I want you to keep in mind, this sailor to be a good sailor when you're awarding the punishment, because when you think of my sailor, he is so disliked in the ship's company that I worry that when you award him punishment, that may be disproportionate to the charge that he is being charged for, to the infraction that he has committed. And so I just wanted you to think about this nice sailor rather than my sailor when you're awarding the punishment. And commanding officer, smiled and he said, "I take your point." And he said that, "Look, if you had not made this point, I suspect I may have been a bit harsher on your sailor, because I agree that no one likes him," right? So the prejudices come in very subtle forms, especially with people that we work, or the people we know, we know of their impressions through the work, whether favorable or unfavorable. So these kind of issues about neutrality and conducting an unbiased investigations become crucial when the investigator is an internal investigator who has knowledge of the parties or may have knowledge of the parties through other people. Competence. Obviously, the investigator needs to be competent. And one of the things that the investigator has to have is a good understanding of law. If the investigator does not understand the law, there will be difficulty in conducting a true fact-finding mission, and I'll explain that further down. Also, the investigator needs to understand policies and procedures. So if there are workplace policies that are at play with respect to that investigation, an investigator needs to have a very good understanding of those policies before he or she conducts that investigation. Now, talking about understanding of law, there's a point which is very important that I want to make, and that is that oftentimes fact-finding is driven by underlying legal issues. So even when you are trying to find some facts, the way you ask questions, the direction of your inquiry, how deep do you go with respect to asking questions, is often informed by the legal issues that you are grappling. Let me explain that by giving you an example. Let's say that you are investigating a complaint from an employee who says that he was discriminated because of his disability, because the employer failed to accommodate his disability issues, right? And the disability issue, he says, is that he had a back pain problem over the last several weeks, and the employer still asked him to perform certain tasks that he should not have done because of his backache. So when you are conducting an investigation to determine whether there was a breach of human rights code, whether there was discrimination or not, you obviously, on the basis of common sense, you will first of all find out whether that employee indeed had back pain or not, right? And so you look towards medical evidence or other evidence to confirm whether that individual had back pain. But then, the second inquiry that on the basis of common sense you may ask is that whether the employee asked for any accommodation, right? Whether the employee went to his manager or went to the human resources and asked them that, look, I have a back pain, can you not assign me those duties? And let's say the answer is no. The employee says, no, I never went to my manager or I never went to the human resources to ask for any accommodation. So based on common sense, your inquiry may stop right there. Because the common sense will say, well, he never asked for it. How is he going to get the accommodation? It makes sense. You want accommodation on the basis of disability. You have to go ask for it. It will not be divined on the employer to provide you that accommodation unless you've asked for it. But if you understand the law, your inquiry will not stop there, because you would know that the next the level of inquiry that you need to determine is whether, regardless of whether the employee asked for accommodation or not, whether the employer had any knowledge that the employee had disability issues or back issues, right? And if the employer had some knowledge, then the law imposes a procedural obligation on the employer to inquire whether the employee may need some accommodation and to follow it more, right? So that understanding or that factual inquiry is now driven by your understanding of the underlying law of discrimination. And absent that understanding, your inquiry may not go deeper, your inquiry may not go in the directions that an appropriate inquiry should go, right? And so just to give you a clear understanding, there is actually a case in our jurisprudence on those facts where the employee who had worked for a car dealership or something, and he had these back pain issues, and he never asked his manager to accommodate him because of his back pain, but he was clearly seen leaning by the walls most of the day because of his back pain issues, and he was obviously seen in pain, and his manager actually acknowledged that he understood the employee to be suffering from some sort of back pain, but because the employee never asked for any accommodation, he never took any initiative in providing any accommodation, right? So the important point is that fact-finding oftentimes is driven by underlying issues. So if the investigator is unclear about the law, does not have the full understanding of the law, even though the investigator's mandate may be limited to finding only the facts that the investigator may uncover may not be complete. So it is an important thing, and I kind of find this to be sort of an issue of competence, that the investigator needs to have the understanding of law and the underlying policies to properly conduct an investigation. With respect to efficiency, an investigator needs to conduct timely investigation, right? So when you hire an investigator, you need to make sure that the investigator has sufficient time to allocate towards an investigation, because it is important legally as well as otherwise that an investigation is conducted in a timely manner. Also, part of efficiency is the investigator's ability to dig deeper when warranted. So when the investigator is asking questions, and then based on the answers provided, based on the evidence that is presented, sometimes the evidence leads to certain other issues that may need to be investigated further. The investigator needs to figure out, based on its mandate, based on the issues at hand, does it make sense to dig deeper or not, right? This is sort of a judgment call, and again, the investigator needs to be able to do that efficiently. And similarly, the investigator needs to have the ability to avoid irrelevant issues that may arise as part of the investigation. So I can give you an example in one of the investigations that I had conducted some time ago, where when I was investigating this person who had filed this complaint of harassment, as part of the investigation, she raised this issue in my examination of her, that she had faced similar harassment from the same employee some 10 years ago. So there is an obvious question now on part of the investigator, whether the issue that she is raising 10 years ago, does that need to be probed? If it needs to be probed, to what extent? How deeper do you need to go in investigating that issue, right? And so these are issues, these are judgment calls that the investigator make at every step pretty much of their investigation, that in which direction the interview needs to go, in which direction the fact-finding mission needs to go, what kind of pitfalls to avoid, what kind of issues to avoid, what kind of issues to focus on, what remains relevant based on the mandate that is given to the investigator. So efficiency in conducting an investigation is also one of the essential qualities of an investigator. So to sum it up, selection of the right investigator is one of the most crucial steps in my view, and then a bad investigation can cause more harm than good, and it is very important to select the right investigator for your investigation. Hopefully this gives you a good sense of how to hire a good investigator for your investigation, and we'll talk more about these issues in our following lectures. Thank you for watching.